Jim, thank you so much for joining us today. I apologize again for the technical difficulties. How are you doing this morning?
I'm great, and thank you for having me today.
Yeah, no, it's our pleasure. This is an extremely unique and timely topic, and I couldn't think of anybody more qualified to discuss it than you. So thank you so much for lending your expertise and intellectualism here. I know Pierre's going to jump in shortly to join you once he gets himself back online, but I'm not going to, without any further ado, thank you very much for joining, Jim, and take it away.
Great. Sure. I'm happy to go ahead and kick it off. Thanks everyone for attending today's session. And today we're going to talk about transaction flow in the world of COVID-19 and new legislation and the security of these transactions. So really what we're talking about here, let me see if, there we go. So today you'll be hearing from myself, founder and CEO of Board Packager, and also Pierre, Debbas, who will be adding additional color with regards to transactions and how they are getting done in this environment and how we're able to have the consideration of security with it.
Just want to say hi. I'm sorry I'm late. I've had some technical difficulties on my end. So hope everyone's doing well. Today, Jim's going to be the main man. I'm really here just to chime in on the transactional side, be able to issue the credits, but it's a great session. Hope you guys are doing well, enjoying our rotation of by every other week CE classes and every other week Q&A. So it's been a lot of fun, but I just wanted to say hello. And Jim, I'll turn it over to you and I'll just jump in wherever, wherever my roles fit.
Thanks, Pierre. Good to see you. So when we're talking about the transactional flow and digital security and how it's impacting real estate, there really are three different aspects that we need to pay very close attention to. They are really the business imperative. How do we get these transactions done and how do we get them done in an efficient and secure fashion? The compliance issues, what do we need to be aware of in terms of the laws and the regulations? And then finally, the practicality of being aware and taking action regarding these compliance with the laws and the regulations. So it's those three really very important aspects, really, and how do we assess and how do we implement? So with regards to the business imperative, really COVID-19 and dealing in this environment, we've been at it for 2 months, almost 3 months now. We understand that it's been a major global disruption, but also has acutely impacted transactions here in New York City. New York is a global destination and there are global buyers and sellers of property here and also renters of property here. But even though it's a global market, it's also very local, and we need to pay attention to not only the laws and the practices of those that are coming globally, and both US as well, but relate that back to what's happening in New York City. Really, it's very important that owners can sell and lease their units during this time. It is taking longer and it is a little more difficult, but really trying to make this more smart and more secure. Concerned clients are looking to real estate professionals for guidance on how exactly to navigate these waters. Brokers are understandably concerned about the transaction, and owners just simply want to be able to move in and to move out. And of course, we've heard about varying policies on different buildings and whether that's allowed, and aspects regarding trying to cure for this in terms of escrow and things like that. But generally, with regards to some of these new government orders and rule changes, we're used to a little more lead time in New York City to try to implement these, but certain circumstances are dictating that we have an action and a reaction. So with regards to that, REBNY actually initiated in April and issued a guide to practices in order to facilitate remote real estate closings using technology. The executive order was, yes, closings must continue, and they are an essential business. Real estate is an essential business. But exactly, what sort of technology should be used for this diligence, and what are some of the security issues that we must take into account? Well, because of the fact that there was the executive order on March 22nd, and offices both for management and for brokerage have been closed altogether, or they're operating on skeleton staffing, the traditional practices of getting diligence on a building and also submitting applications, both for any and all types, purchase, lease, sublease, refinance, transfers, even alteration agreements, those practices must change in order for these transactions to continue to be processed. Really, what starts this off, if we think about the genesis of an entire transaction, is getting the diligence on a building, understanding the policies and what's required in terms of the applications, the fees, who pays what when, and looking at certain aspects of a building's financial health. So being able to actually get a financial statement and review it, understand that. But really, one of the biggest things that is a bottleneck in the physical world is the meeting minutes review of the board of directors by the attorney who typically is on the buy side of the deal, if we're talking about a purchase transaction. So this world is such that, as we know, attorneys who are representing the buyer typically have to call a management company, have to schedule an appointment, a conference room is allocated, and then a physical book of meeting minutes is delivered to the attorney for review, usually for a set amount of time, 1 to 2 hours. And the attorney is reviewing and checking off the box on the diligence aspect for the board minutes review. And then once that's complete, she or he leaves the office. Now, that's not conducive in a world of COVID-19 and these closed or skeleton staffed offices. So how do we account for that in a digital world, and how do we make sure that that can be secure? Well, I know that there have been some bridge gaps that management has been able to issue confidentiality agreements to attorneys to execute, and then send the required minutes via email. Now, that has its own set of issues, because technically those minutes can be passed along. They can be, of course, downloaded and printed. Nonetheless, the confidentiality agreement, dictates the treatment of that. And Pierre, I might ask, what are you seeing in terms of diligence and reading the minutes on your side?
Yeah, it's a great point, because we're starting to see managing agents open up to the concept of emailing us minutes. Historically, you always had to go to a property manager's office to read them, because this way they couldn't never leave their office, and the whole world wouldn't be aware of any issues that may exist in a specific building. To be honest with you, when we sit here with all our smartphones and cameras and our 80 gazillion pixel feature on our iPhone, it's kind of counterintuitive. If you want to snap a picture of minutes, you can easily do so. One of the benefits of this whole mess we're going through is I think the world is finally going to become more digital with real estate closings. I was just talking to, someone in my office this morning, because we're trying to, think about reopening and what that will look like, and when, how many people we can have at the office at one time, and then how closings will take place. And I was joking, I'm like, I don't think you're going to ever have a day where you're going to have 12 people in a conference room to close on an apartment again. It's kind of a silly concept. If we really think about it, we just got stuck in our old ways. I think for moving forward, closings will become virtual, become the norm. I don't think at some point, we'll have in-person closings at all. Jim, I'm hopeful, one of the things I'm interested to hear is that are managing agents uploading their minutes to Board Packager for people to access? You know, you provide a secure platform, right? Like I have a login, I go into your platform, I access minutes. You know, it makes us more efficient. It saves time and cost on everybody's behalf, right? Property manager doesn't have to deal with me hounding them to go read minutes. They don't have to open the door, provide me a book, provide me a conference room space, right? I don't have to send somebody to commute, you know, potentially over an hour round trip to go read, you know, to go read minutes. It's a far more efficient way of doing it. So
it absolutely is, and I'll add to that the aspect of cleaning after, before and after an attorney or his or her representative comes, because that also is a cost that management has to bear. So yes, the answer is that we have developed a system that is going to be deployed this week. We have several different management firms that are acutely and keenly interested in this technology. And what it will allow to do is that an attorney requesting to view the minutes can actually initiate that request through the platform. And then on the receiving end, staff at the management company verifies the attorney and then allows for a portal to be opened. Those minutes are uploaded into the portal. The attorney then is notified, gains access, and has a certain time period, say 2 or 3 hours, that begins from that point of access. And the attorneys can access at any time of day. If they are sitting, having insomnia, it's 11 o'clock at night, they know they need to do this, they can log in, they can start the timer.
For the record, don't expect me to be logging in reading minutes 11 o'clock at night. Just throwing that out there. I'm always around, always working, but that may be the exception.
But it is possible, Pierre. So that's why I mention it. At the same time that count starts, and if for some reason the attorney needs to leave, they can log out, they can log back in. But and once that 3 hours or 2 hours is up, then access is revoked. There is absolutely no way for an attorney to print or to download the documents, and once again access is revoked, they no longer have it. So that is a way that management is going to, I believe, begin really disseminating, and it's going to change, I firmly believe, the amount of time that it takes to perform this diligence, and therefore get us to accepted contract or fully executed contract much quicker. So that is, I believe, a benefit that's come of all of the COVID-19 issues. So important to note, and we're really proud to be able to enable that. So right, you know, we're trying to shift how the process is done, and I might add, you know, it's even more secure to disseminate the minutes via a platform that allows a certain time period and then revokes access, versus sending a confidentiality agreement via email and then sending minutes via email.
Yeah, I couldn't agree more wholeheartedly, because I mean, look, confidentiality agreements are great and all, but you know, go enforce them, right? You know, in reality, you send somebody minutes, their email gets hacked, or the wrong person in their office forwards it to somebody, you know, things are going to get out there. Having a secure portal, I think, is going to be the wave of the future. I think it's the best way to go. As a practitioner, I'd be elated to have access to something like this, you know, in order to streamline my process.
Right. Yeah, exactly. So let's talk about, you know, we've completed the diligence aspect, and now we're really on to applications. And if we think about how we've compiled them historically and for decades, brokers have received the materials that are required for applications via email, fax, FedEx, courier, etc. And they've compiled via, you know, I remember first getting into the business and seeing these huge accordion files on where all of the different documents were collated, and that's how brokers put together a board package. You know, that if we're talking about a secure environment, yes, it's within the office, but at the same time, individuals' information, personally identifiable information is out there too. So really trying to get a process and procedure that protects that individual applicant's information by direct upload into a secure platform was really something that is essential.
Jim,
Yeah.
can I ask you a question? It's June Gottlieb from Warburg. Before we even get to the application, in terms of getting materials that attorneys need to do their due diligence, heretofore, offering plans, financials, all that kind of stuff was a source of revenue
Right.
for managing agents. How are managing agents going to be okay with losing that source of income, and they're going to look to replace that income with some other fee that they can exact for something else? Could you just talk about that, about why managing agents are going to want to give up fees that they have received before?
Well, they're not, is a short answer, June. So with Board Packager, the building page is created, and then all of that diligence is uploaded. We're talking financials, offering plans, amendments, house rules, proprietary leases, questionnaires. So the same charges that a managing agent have traditionally charged are still charged via the platform, and management is collecting those fees. So that is it was a way to enable the immediate dissemination, so that a broker didn't have to find out who managed the building, who at the management company to call, send in a check for a financial statement or an offering plan, and then wait to receive that via email, PDF, or physically having to come to an office. So, but that is the answer currently, that management is still charging those fees.
Okay, and when everybody sends in their different attorneys have different questionnaires.
So those fees are processed through the platform as well. Management receives the questionnaires, they fill out, and they return to the attorney.
So they're still doing it. They're still doing the work they did before. In other words, the process is the same. The only difference is that it's being sent over, it's being
Yes, you as a broker can create an account, log in, get the information that you need on policies and financials, things like that. And the attorney can do as well. So the difference is the medium and the methodology that is being used to disseminate.
Got it. Thank you.
Sure. So if we're talking now back on the applications, especially now in a COVID world, it's been kind of crazy to hear boards of buildings that are actually not part of a board packager network to write to us to say, hey, can we get on your system because we don't want to receive COVID virus laced paper from management to review. And if they're even there, a lot of people, of course, have second homes and have gone, to other locales. But so, that's an interesting part of the business imperative, that we need to ensure that agents can have a platform or any sort of really secure access to enable their applicants to upload secure or sensitive information, fill out, sign, compile, and then send that direct to management without having to put an email attachment or disseminate via a flash drive or paper, right? It minimizes the person-to-person contact. Management can collect fees digitally versus paper checks. And oftentimes, as we've discussed, there's skeleton staff if management's even open at all, and they're maybe getting checks once a week. So just as part of the board packager platform, management not only can collect the fees that are due at the application submission, but they can also collect the fees that are due at closing. And that's something that's been new in this environment as well. We've enabled that for the last month or so. So that's helping to ensure that the transaction continues and is done efficiently as possible. So if we talk about interviews now, historically, if we've done a webinar interview, it's been very rare, and it's very rare instances that boards, especially of cooperatives, have allowed that, right? But now we are in this world where management is allowing, and boards are allowing for FaceTime and Skype and Zoom and Google Hangouts with the ability to be recorded or not recorded. And so I know that there has been some issue regarding security on Zoom. And so there are other platforms out there that have a bit more in terms of data security and the ability to, or inability, as the case may be, to not hack. Pierre, what are you seeing or what are you hearing in terms of interviews being conducted via these mediums?
I have a client last night. They're in contract for about 4.7 million on a co-op, and they just did their interview via Zoom. And the board all showed up, just like we're doing now, and they got approved. They loved them. I got an email 11 p.m. last night that forwarded from the board president saying, "Great to meet you. Can't wait to welcome you to the building. Formal approval will be issued tomorrow." So I think that, look, the security component's a little frightening because Zoom's been getting hacked. I don't think when Zoom was created, they expected the entire world to be using it multiple times a day.
Right.
I think it's going to be to their advantage. They'll figure it out, I'm sure. But, from a security perspective, once they figure that out, the interview process, we're not worried about. The other things we're worried about security-wise, mainly social security numbers and wire instructions. But to be honest with you, we've implemented policies as of a number of years ago in how to initiate that information. So I'll give you a horror story.
Let's go on and let's talk about closing transactions, Pierre, which is this next slide, and the differences in virtual versus remote and virtual notarization, things like that.
Right.
See.
So we'll talk about the notary. The wire component, though, in my opinion, is most frightening because we have a lot of email hacks that are taking place out there, and crazily enough, there's still some lawyers out there who operate on an AOL or a Gmail account. And I'll give you a terrible story. About 5 years ago, I was working on a deal. We were representing the buyer of a townhouse for about $5 million. And we had a deadline of Friday at 5 o'clock to sign. We rush out the wire. We get everything out. We email the attorney, please send us your wire instructions immediately. We're getting this set to you via wire. We're not going to message you a check to save time. His email gets hacked. It's an AOL address. The guy hacks it, sends me false wire instructions, and he's chiming in on the email like he's part of the deal. Like, look forward to receiving your wire. We'll send you a fully executed contract upon our receipt. And sends us a wire. My office wires it out. Luckily, I caught it that the instructions were some random bank in Pittsburgh. We were able to call our escrow account, retract the wire, luckily before it got processed, and basically save ourselves getting stolen from $500,000 of client money. It would have been an absolute catastrophe. And that's the stuff that you're seeing going on. So ever since, we've been implementing secure email, encrypted emails, where, for instance, I just sent wire instructions to somebody today. I type encrypt in the subject line. It automatically sends it secure, where that person has to go to another site to open that email to see the instructions. And then I ask them in a separate email to call me to verify it. So then we get on the phone where I know who I'm talking to. So it's not the guy who's getting on the email pretending, to be part of the deal. So that's how we deal with wires and in social security numbers as well. Now, Jim was talking about notarizations. Notaries, remote notaries and virtual notaries, it's really going to come down to what's the bank's policy. If there's deals involving financing, some banks are coming to terms with this a lot quicker than others. It's going to be a matter of time, but eventually, a lot of banks now have accepted it, and that's how we've done all these virtual closings we've done. I mean, we're doing numbers of them every single week. Nick, you guys are acting as escrow agent on every one of these deals. Like,
yep.
What are you seeing on the virtual notary front?
With the
So some of the upside here is that I'll say it like this, about 15 states not called New York have already adopted the virtual notarization system that we're currently using today.
And that's raw. That's the remote, right?
That's correct. So if you don't, Jim, do you want to talk about the distinction for a second?
No, please go ahead.
So there's Jim brought up a great point. There is a distinction between Avon, which you may hear, which is audiovisual online notarization, which is an unsecured tool. Mm-hmm. This would be your Facebook chat, WhatsApp, Zoom, even to that extent, technologies, versus RON technologies, remote online notarization tools, which are, there's about, I would say, 7 to 10 of them in existence that are secure portals that have been adopted by title companies and escrow companies nationwide that are also recognized by banks as secure tools that you can use for these purposes. So TitleVest, by way of First American, has access to about a half a dozen of these tools that we've currently used both with banks and licensed over to law firms like Pierre's. So where Pierre's firm has become an expert in these remote online notarization tools, so they can go ahead and start using them for closings as well. So great point, Jim. There is a distinction between the tools, and at TitleVest, we have licenses for about 5 of the secure tools that has allowed banks that have concerns about security, like Wells Fargo and Chase, to go ahead and start closing loans in the city.
Right. Pierre, what are you seeing in terms of just the final touches on walkthroughs and things like that? I know, I've heard varying accounts that in many instances, the superintendent of the building is more than happy, and if the owner is not in the building, to facilitate a virtual walkthrough. Or I've also heard instances where a broker who may live in the building has agreed to work with another broker who is the buy side and facilitate that as well. I'm curious to know what your experiences have been.
Yeah, in all our closings so far, every walkthrough has been virtual and facilitated through the agent. So I actually don't think I've had one where the super conducted the walkthrough, which is interesting. I didn't think about that. For those of you guys listening today, I mean, have any of you guys done virtual walkthroughs yet for any remote closings during the last 2 months? If you have, just unmute yourself real quick to chime in.
We were actually just talking about this in a company-wide meeting. I'm sorry, June Gottlieb from Warburg. We were just talking about this in a company-wide meeting because you have doorman buildings, you have non-doorman buildings. The non-doorman buildings are much more flexible about what can be done, and somebody has to open the door. So right. What we were talking about is if you open the door but you don't go into the apartment, therefore you're not showing, you're not violating the governor's shelter-in-place mandate. It's a tricky thing. It's sort of the bottom line, particularly because a lot.
It's really tricky because if I'm an outside, one of them I had the broker lived in the building, so that was easy to facilitate. But if you're a listing agent or a buyer's agent, you don't live in the building, and you're, like I know in my building, you're not allowed to have guests come. You can't, unless you are an occupant in the building, you're not allowed in the building right now.
Right.
So it really is difficult to facilitate. But I think, June, to your point, it's a matter of case by case. Some buildings are going to be a little more lax on this. Others, you may have a broker that lives in the building that can do it. Like Jim mentioned, the super, but I'd be curious what other people have done.
You also might need to have the owner, the owner who is a shareholder or an owner, whether it's a corporate condo, either they need to do it or they need to make it happen. It's not, we don't have leverage with the board or the super, but the owner does. So the owner really needs to get this facilitated.
See, the problem with having the owner, so the owner, I don't think can actually conduct the walkthrough because they have a conflict, right? Like if they know something is defective or something's damaged, they're not going to show it to you, right? So that's the fear of having the owner do it. But June, to your point, you're right. Like, you don't have any leverage on the board or the managing agent or the super. So it's a matter of getting creative without, really breaking the rules. It's a tough thing, but.
I think the only way to do it, if the owner cannot do it, is we would have to do a FaceTime walkthrough where the principal is there, the buyer goes through, and we are on FaceTime with them, and we, look as carefully as we can, but we can't represent something that we're not physically, that we can't see in person.
Correct. Yeah, we've had that happen once so far too. But I'll be honest with you, I have not had the walkthrough aspect to delay any of our closings.
Have you had escrow put aside to account for anything that may be deficient?
Yeah, one of them we closed without being able to conduct a walkthrough. But I was representing the buyer, and he got a credit in order to close early, and it was to his benefit too because he preserved all his favorable loan terms that he got, as a result of this. Right, the interest rates are at historic lows. And it was in everybody's best interest. So given the fact that there was also a credit factor that was taken consideration there, but we've utilized escrows as well.
Great, and good to know. Yeah, and in terms of, just to bring it back to the security aspects of all of these new digital means and methodologies, I think that with regards to virtual notarization, that's really where it comes to play, especially in Avon, where an attorney or a notary is requiring the individual to actually enter into a FaceTime conversation, show an ID, and then execute a physical document, scan it, and send it on. That comes to play as well, more so than the walkthrough, just simply because of the personally identifiable information. But that actually is a nice segue into really what the compliance imperative is and some of the cybersecurity, privacy, and other regulations that have been enacted. And so we talk about, and we will spend quite a bit of time today on the SHIELD Act, which is applicable to New York State. But the SHIELD Act really is one in many that has been enacted as a result of what, in my mind, kicked it off was GDPR, which was the data protection for European citizens. CCPA in California was really one of the first US initiatives. And it affects transactions. Those laws actually affect transactions in New York because a resident of say, California, if he or she is buying or transacting with a property in New York, then those laws also apply. So the SHIELD Act really was New York's answer to the data privacy and protection of this person identifiable information. And so we'll go into that, and it was kind of interesting for me to learn that really the real estate industry in 2018, 2019 was actually ranked second for cyber attacks. And we as agents saw that and Pierre alluded to, or actually spoke about it in great detail regarding, the insertion of different wiring instructions. That was one of the first, I think, wake-up calls for our industry. But it's ranked second behind biotech and ahead of pharmaceutical in terms of cyber attacks. And so it's an important aspect and something that absolutely needs to be addressed. A couple other things that I wanted to throw in were the timely cooperative application decision law that was enacted in Rockland County, and the cooperative housing corporation disclosure law, which was Westchester County's answer to certain time limits that need to be adhered to with regards to receiving applications and processing them and board review. These are related to security because it does have an impact. They do need to be securely administered, but they have an impact in terms of timing and other considerations. So if we talk about the SHIELD Act, which stands for Stop Hacks and Improve Electronic Data Security, what exactly is the SHIELD Act? Well, it requires businesses in possession of New York residents' private information or personally identifiable information to develop, implement, and maintain reasonable safeguards to protect the security and confidentiality, including but not limited to the disposal of the data. And this bill is New York State Senate bill signed into law on July 25th of 2019. The bill is not only for the implementation of safeguards, but more importantly, it's the notification of when there has been a breach. And who does it really affect? Well, it affects any business with access to personal and private information of New York residents. And that can include brokerage, that it could include management, that could include board of directors of buildings, which are corporations. So it really involves quite a few of the stakeholders in this process. Anybody that is submitting an application as well and uploading this personal information. And it's not just what you would think in terms of Social Security numbers. Of course, that jumps to mind very initially and very rapidly, but it's also including anything that's not publicly available biometric information, such as photographs. The law actually covers that. And so when exactly did this go into effect? Well, as I mentioned, it was signed into law on July 25th of 2019. The law actually went into effect on the 22nd of October in 2019, but penalties didn't start until March 20th of 2020. Now, of course, with the advent of COVID-19 and all of these other considerations, I doubt that there's been a lot of time and effort and attention given to this, but nonetheless, as things are coming and becoming more digital, no doubt that it will have more of a focus. And with regards to this, when exactly any sort of, if a breach does happen, who actually is, who is that entity that is ultimately responsible? Well, again, it's anybody that has unauthorized access to this private information. And so if there is a breach discovered, then there is a notification period that must happen to all affected persons, and that's applicants and owners or guarantors or whomever is receiving and disseminating this information. And there are damages for actual costs or losses, as well as consequential financial losses that can be incurred. What's interesting is that now we've seen the advent of cyber insurance policies, and those policies coming into effect. Really, actually, the amount of companies that have come on the scene in terms of underwriting these policies has increased greatly over the last year and a half. I think at one point, maybe in 2018, there were roughly 15 or 20 different firms that offered a cyber insurance policy. And now we're seeing upwards of 40. So there's more focus on this for sure. And really, it doesn't pass muster any longer for anybody that's a stakeholder in this process to say, I'm not that computer savvy. There is common law that's associated with this, and there's a common law duty to not be negligent in handling this particular data. So let's talk about also the timely co-op application decision laws and the corporation disclosure law that were implemented in Rockland County and Westchester County in 2018. So this legislation was enacted really on the premise that people approach the application process in good faith. Applicants approach it in good faith, but face the very real prospect that they may be left in limbo when it comes to their housing situation, simply because a cooperative association isn't, or management, as the case may be, isn't responding in a timely fashion. And so the legislatures wanted to enable a system that provided an applicant with written acknowledgement of receipt of completed purchase application in the case of Rockland County within 10 days time. If the application is deemed incomplete, the cooperative has 10 days to notify the applicant in writing and explain what is required to render the application complete. Now, once that is accomplished, then of course the application is on to the board to reject or to approve. And this must happen within a 45-day period. And with this also too, management and boards have to be very cognizant of these timing factors to make sure that they are not in violation of this particular law. And as a result, Board Packager does have clients, management companies that do manage buildings in Westchester and Rockland. And this is part of the software that once an application is received, the timer starts, there are notifications, et cetera. So that was something that you know, it was a hasten to a digital format, because really, you know, it was very hard to track when a physical paper application was delivered to the office and whose desk was it put on, and did that individual transfer agent respond within a certain time period, when was it sent to the board. The audit trail was very difficult. So, but the digitization of that and the securitization of that has allowed for really better compliance with this law. Now, with the Cooperative Housing Corporation Disclosure Law, some of the time periods are stretched from 10 to 15 days for receipt of application and notification of completion, when 60 days to either approve or reject the application. But it also adds another layer, and that's the prevention of discrimination in sale and transfer of stock to a person based on their identity. So when we're talking about applications and the different methodologies that they've been compiled and administered and disseminated for decades, we talk about some of the misconceptions with regards to compliance. And one of the predominant misconceptions is that paper is the easiest and the safest method. Paper is not that, for many reasons, and I've alluded to some of them previously, but paper does not have a chain of custody or an audit trail. It's very difficult to, when you know, a broker or an applicant is, you know, compiling all of these documents and then getting them via FedEx and fax and email attachments and things like that, compiling them and then sending them on. Oftentimes, I know that you know, brokers will hand deliver these packages to management companies because they can't necessarily be assured that a courier is going to deliver to the appropriate person. Or there have been many instances where the courier has misdelivered and these packages have gone to the wrong or unintended individuals. Often too, paper is lost and misplaced. And let's talk first about that. I know of instances where applications have been sent to a building and a box with the applications, you know, put in a super's office or in the basement, and you know, that application can't be found until, you know, somebody actually really traces back the steps, and maybe a week or 10 days later it's actually discovered. Even properly disposing of paper applications is paramount. You can't necessarily be assured that every building has the proper, or management companies that manage these buildings have the proper protocols and procedures to ensure that once a board has rendered a decision that the board no longer has access to this application, that it's shredded, or, you know, maybe in instances just thrown in the trash. So there is no assurance there. But even without, if we're talking this physical paper world, even if only a single copy does exist, a paper application can have pages removed without any sort of detection. And so that's also an issue too. Now, if we're transitioning more to emails and flash drives and file sharing, which is, these are digital methods. Emails, Pierre was alluding to, or it did mention actually that there are secure emails, but even encrypted emails still require downloads in order to access attachments. And if we talk about methodologies like flash drives can be intercepted, they can be misdelivered, and file sharing services like Box or Dropbox, they're a good tool in terms of directing an applicant to upload documents into a secure environment versus hosting them on a email server from a broker, right? But at the same time, links can be forwarded to anyone, so it's not secure from that aspect. But really, the key takeaway here is that any misplacement or misdirection, loss, or improper disposal or archive of personally identifiable information, accidental or otherwise, is now considered legally a breach. So let's now talk about the compliance imperative as it relates to a chain of custody. When we talk about this and the assurance of a digital transaction being secure, we think about who is really responsible for the personal identifiable information of the applicant, who saw it, who kept a copy of it. And as I mentioned, it's really anybody in the process, and it could be brokerages, property brokers themselves, property management, boards for both cooperatives and condos, and landlords. And in these certain aspects, when a document that has PII, when it's in transit, before, during, or post submission, the acceptance or processing and disposal protocols, plus how is it recorded and how is it archived? Are management, is management keeping a physical copy in the office? Are they shipping it off site? Are they destroying these copies for legal purposes? They need to retain for a certain period of time, but there are ways that can be these documents can be retained more securely. So, and really about the chain of custody, it's important to note that there really should be a minimization policy. The fewest number of people with access to this personally identifiable information. And we've seen this at Board Packager. There are a lot of forms that are part of these applications, and it's one of our jobs to help work with management to minimize the amount of times a social security number appears on a form when it doesn't necessarily need to be there. And there's a lot of duplication on these forms, and that is actually really providing more of an opportunity if that's the case, and especially in the paper world. And so we need to actually think about also a chain of custody, and when we're in the paper world, when we're printing or copying or scanning, a lot of these machines, they will save these images, and they'll remain on the device for, say, a remainder of a lease. A lot of office equipment is leased and then it's returned. So what sorts of policies and procedures are we doing in terms of trying to delete that information and expunging that information? So these are some of the imperatives regarding chain of custody of a document. And really, data, what's interesting, it can't be transferred to a transit service. The responsibility for FedEx, the United States Postal Service, UPS, or even messengers or couriers per their legal terms of service. So if data chain of custody cannot be proven, documented, or audible, there is a potential for a breach of data.
Hey, Jim, let me chime in on that because I think it's a great talking point for us. Because we've had this issue for a number of years with having original documents from closings. And, you know, our office, I think, you know, companies have gotten away from paper as much as humanly possible.
Sure.
Where we actually scan into our system all the relevant documents from closing and all the relevant documents in the file, send the client the package via secure email. And we have a shredding company that comes every week and takes all the paper that we don't need and destroys it. So that way we don't risk like ACRIS documents floating around the street with client social security numbers on them. And then anything you have to maintain, we send to an off-site storage facility in New Jersey that's secured. So essentially, besides active files, we have no paper in the office. I think in a lot of it, we do that largely because, like, look, I don't want to point the camera to my desk, but I have all these files on my desk. Who's to say a cleaning person doesn't come in and peeks in and sees the name of a, you know, high-profile client and their social security number? I don't leave that info on my desk. Luckily, this is all my OCD notes. But, you know, in reality, like, that is a fear of everybody involved. And it's a fear for you guys. You guys are assembling the package. You're printing things in your office. Things are being thrown around, lying around. The last thing you need is it to catch anybody's eye. So I think, you know, again, this is kind of the same sentiment that our whole process of what we do will go virtual and go through the means of technology at some point. And it protects all of us. I personally can't wait for the day.
It sounds like you've taken a lot of the appropriate steps. And, you know, there are others, of course, that act more proactively and others that don't. And so I just remember early on you know, going and seeing some of these offices and seeing all of the paper on the desks and file cabinets and stacked on file cabinets. And so, you know, really protecting that data became an imperative. But you know, if we talk about too our data custody protocol, you know, all applicants' personally identifiable information must be secure, especially under the SHIELD Act. And you know, with regards to it, there are three important aspects. All parties must have the official privacy protocol and permissioning. How are you onboarding certain individuals and devices? What sort of security clearances are you giving them? Email can technically be a data breach. If we think about some of the emails that the services and platforms that we use, Google and AOL, Yahoo, these services, they provide free accounts, but nothing is necessarily free. They scan emails and they look for keywords so they can sell these keywords to advertisers, and that's how, you know, a lot of this is subsidized. So technically, if you're disseminating information via email, there is that potential for the data breach just by nature of how these services run. And every breach is subject to penalties, and there are notification periods, et cetera, as we talked about with SHIELD Act. Now, cyber policies protecting some of this are relatively new, and they don't have a lot of experience with claims arising. But you know, they'll get a little wiser as, of course, time goes on. But really, you know, it's important to think about from, you know, a broker's standpoint, management, board member, you know, all parties have, you know, really should consider a security program and protocol to be compliant with law, or it takes steps towards that. Again, that was if Board Packager wouldn't have been created had we not been able to absolutely ensure the utmost in data privacy protection and security. Email, especially free platforms, as I mentioned, you know, those emails are scanned, So it's a potential for the breach. And, all parties really involved need to be compliant or potentially face legal penalties. So with regards to the mandated response time, really the important takeaway here is that property management and cooperative boards really should and must follow strict timeline windows for the application review or face legal penalties. Now, it's what we've seen is that while this really is Westchester and Rockland County, what tends to happen is these laws, these legislators essentially cross-pollinate this legislation. So prime example of that was the LLC disclosure laws that were enacted last year. And they were for the entire state of New York, but a lot of those provisionings were rolled back for New York City. And Pierre, I think that you probably have seen a little bit of that in terms of, the real estate transactions and people buying with LLCs and what sort of concern that became.
Yeah, it's funny. One of our niches in our practice is representing foreign nationals and creating these appropriate structures to mitigate their tax implications. And, what does transpire as a result of that is there is a layer of anonymity for the public eye. So not everybody who's utilizing these LLCs and these offshore corporations is looking to high shield anonymity. It's really for tax planning, a lot of them. So to your point, Jim, the Treasury Department, for those you guys likely know, requires anybody who buys in the name of these entities to disclose their identity to the Treasury Department. And it's really for anti-money laundering issues and, a lot of the stuff we're talking about today. So I think that sentiment's only going to carry further. I think it's going to be expanded upon. It already has been expanded upon significantly. I think we're in year 3 maybe of this, at least 2 years in since the Treasury initially passed this. It may have been August 2018, if I recall correctly. And it's spread through, I don't know how many states it's in now, but it's in every major market in the country.
Right. So if we think about how some of these laws, tying back to this timing and processing of applications in Westchester and Rockland, could very well be that New York City will adopt some of this legislation as well, and something similar happen within the 5 boroughs. So important consideration. Let's talk about recommendations in terms of implementation. Now, what I think is important to really try to understand is really a methodology for tracking the custody of a document or who has had access to what. And permissioning is really very important here. And especially within the board packager platform, agents and can actually dictate and direct who sees what. That actually is limiting the exposure of personally identifiable information to participants and therefore helping to reduce any sort of likelihood. Now, having a data map and understanding what information, and this is really more for cooperative boards and property management companies, but what information they have and where is it stored and how is it used. If we think about the 3 real different types of mediums, we have mobile devices, and even more so now the proliferation of mobile devices. We have the phones and the tablets, etc. We have the remote access, and then third-party providers like Dropbox and remote backups and things like that. But if we're talking about the data map and mobile devices in particular, who has access to this information? Could somebody be using an iPad and get this information, but then a kid or a child of one of these individuals then has access to it. They go outside to a friend's house or what have you. It opens up a potential for backdoor entry. with all of these different methods. And so having an understanding, every single permissioning and being able to audit and track that and eliminate any sort of backdoor to a device that has this information is incredibly important. And we even think about, how when we download apps to our mobile devices, what sorts of permissioning are we giving to these companies to access our contacts and our photos and things like that. So it's important really to be aware of that. We need to do systems assessments, vulnerability and penetration testing. And we need to have service agreements with third parties that have protected information. Third parties that are vetting property management companies and boards and brokerages, protocols and procedures. And so, with the board packager platform, it's really a secure process that allows every stakeholder to have their own individual logins and verifications, multi-factor authentication, and we're able to track every single step in that process and to see who saw what and signed what and uploaded what. And so it's important to have those aspects. And then really it's cybersecurity awareness training. It's a business imperative. If we want to try to assure our clients that we are a trustworthy source, so we're a trustworthy entity for their personally identifiable information. And just as I've seen some of these studies come out, Cisco had one in 2019 that said sales cycles are faster for those who meet cybersecurity compliance standards. So that's an important aspect. And really, just in conclusion, so digital security impacts real estate transactions in just a myriad of different ways, from the diligence aspect, as we talked about, to processing the applications and to closing. Stakeholders really must acknowledge and enact some of the actual recommendations that we've provided, the data maps, and establishing some policies and procedures and assessing which systems are best to really try to achieve that outcome. And it's really specific about the focus and the practice of the stakeholder in the process, but nonetheless equally as important. So with that, I want to just open it up to Pierre and to Nick for any sort of further comments, and then I think that we take some questions.
Yeah, Jim, I definitely like leaving the last 10-15 minutes open to questions, because we covered a lot of great information today, and I want to hear from everybody kind of any concerns they have, what they're seeing, and then any issues you've been having with the virtual closing component, virtual walkthrough component, all the stuff we discussed. So with that being said, let's definitely open it up to questions. Just unmute yourself and go for it.
So what kind of influence are you going to be able to exert over the other managing agent companies that they should adopt a paperless system? That would be so wonderful and save so many trees.
Well, absolutely. There is the aspect of the resource and the intensity of the resources that are used to generate these paper applications. I think that the compelling aspect, really, COVID-19 hastened this to digital. Management companies that are considering a system, it wasn't brought into the light as it needed to be without COVID-19. And so these management companies that for instance aren't part of the board packager network or have any sort of processing for digital applications that is safe and efficient, they are experiencing slower processing and closing times, just simply because the office is closed or on a skeleton staff. Many of these transfer agents are working from home. and they don't have the ability to receive a paper copy or a flash drive. Oftentimes maybe they're asking for a PDF that's sent via email. Well, again, email is not a safe medium. So I think that it will, we are slowly, change management is very hard, especially when you've been doing something a certain way for so long. But I do believe that now, well, just really even as of a couple months ago, more and more will come to realize and need to be, especially need to be compliant with the SHIELD Act provisions. So.
But Jim, with all due respect, managing agents are employees. They have to really, they're not in a position to institute new policies. So I think that what's going to happen.
Are you referring to June as related to the board, meaning the board is the client?
The board
Right.
has to be educated. So I was just wondering what you as board packager is doing, what you are doing to not only, it would help your business and expand your business. If you could, what are you doing to influence boards or to get the word out to boards, co-op boards and condo boards that this is a better way to go so that they will then push it through, the managing agents will have to do it?
Sure. So, how we started the business, June, was that we approached some of these management companies and they adopted the software for their entire platform their entire profile of buildings under management. The messaging was that this is a way for us to securely and efficiently process these applications. And boards could still receive a paper copy if certain board members wanted a paper copy, or actually review and comment back and forth and vote via the platform if they were happy getting the digital version. So I think that if we had to go building by building, which we will meet with boards of certain buildings, of course. But had we to do that, we have a little over 2,300 buildings and 160,000 units in our system. So approaching them individually wouldn't have really been possible. So that's why management companies had their buildings as part of their managed network that they put in, and they notified these buildings that this was happening. And of course, a building had an option to opt out. What we did see with implementation in this regard was probably about 5% of the overall portfolio that did actually opt out. And those boards are now approaching the managing agents and saying, yes, in the COVID-19 environment, we don't want virus-laced paper, and we're not here to even collect the applications, and we need to do this digitally.
Cool. Do we have any other questions? Well, while people may be thinking of them, I see in the message board people are asking about certificates. So those of you guys know, we issue Michael and I started a continuing education school called the New York Real Estate Center. That's actually one of the proud sponsors of NYRAC as well. So if you go to our website, nyrecenter.com, you'll see today's class is exclusively for NYRAC members and NYRAC sponsors like Jim, where it's really great for us to have these small intimate sessions. We're also doing, I want to say probably 4 general classes a week to the entire real estate community, ranging anywhere from 200 to, I think Michael has 500 people RSVP'd for his upcoming ethics class. On Thursday, Michael has a great class where he's actually moderating with Paul Massey from B6, who also ran for mayor the last election. So it should be a really good session. You guys can sign up for all of them on our website. We're doing all of this for free during the pandemic, is our way of kind of giving back to the real estate community and showing a sign of solidarity. I'll type the website in now. Somebody just asked me for it. If you guys, if I maybe said it too quickly, my assistant Sam will email you guys all the certificates. Anna will email us our RSVP list. We'll get that over to you guys. And you know, if you guys have questions for Jim, definitely, I mean, you guys should have all his info. I definitely view him as a really important source for what we do. And with, you know, with all that being said, Jim, I'll turn it over to you for, you know, some closing remarks on your end.
Sure. Thanks, Pierre. I've really enjoyed being a part of this and part of the continuing education. You can always reach out to me, Jim at boardpackager.com. Our customer service and support is also, should you be a user of the Board Packager platform and have any sort of questions or matters that need to be addressed, we're at info@boardpackager.com. And if there is anything else that I can answer and provide additional information for, I'm happy to do it.
Cool. Well, if everybody's good on questions, I think we're all set. Thank you guys all for attending today, and hope to see you guys all at our next session.
Thank you, everyone.
Take care, guys.